Hello, everyone. Welcome to today's Charity Village webinar. We're going to get started in just a moment. We want to make sure that everyone has an opportunity to get online today before we kick things off. I can see we've got folks joining from all across the country today, so welcome to all of you. I hope that your day is treating you well wherever you are in the country today. Wonderful. Well, I think we will go ahead and get things started because I know we've got a fair bit of material to cover today. So again, hello to everyone. Welcome to today's Charity Village webinar. My name is Marina Dawson, and on behalf of Charity Village, I'd like to welcome you all today. As we are gathering here on a virtual platform today, it is very important for us to acknowledge that each of us is joining this webinar from the ancestral or unceded lands of the Inuit, Métis, and First Nation people who call Turtle Island home. For myself, I'm speaking to you today from the traditional and unceded territory of the Coast Salish people, specifically the Snuneymuxw First Nation. I'd like to extend my deep gratitude to the Snuneymuxw people for the privilege of living and working on this beautiful land that is their home. And now, before we start today's webinar, I'd like to make a few introductions and quickly run through some housekeeping items. For those of you who might be joining a Charity Village webinar for the first time, Charity Village is Canada's largest online job board for the nonprofit sector. In addition to our online job board, organizations can also post volunteer positions. So if you're looking for work or to recruit talent in the sector, Charity Village is the place to start. We also have a lot of excellent resources for nonprofit professionals, including online courses, articles, fundraising tools, and free webinars like the one that we are presenting today. Now, before we start today's webinar, I'd like to just quickly run through some housekeeping items. So you may have noticed when you joined the webinar today that you were automatically put on mute. Since we have hundreds of participants in today's session, it is important for us to minimize the amount of background noise so that everyone can clearly hear the presentation. But you can still ask questions and make comments using the question box at the bottom of the Zoom control panel. So just look for that at the bottom of your screen. We will be taking questions at the end of the webinar, so just submit your questions as you think of them. We'll do our best to get to as many as possible. And you can also email your questions to webinars@charityvillage.com. If you happen to encounter any technical issues with the webinar today, either with viewing the presentation or with the audio, please also let us know in the question box or by sending us an email. We'll of course do our best to get any technical difficulties resolved as quickly as possible. But in a worst case scenario, just remember we are recording today's webinar. You will get that full recording by email, most likely by tomorrow morning. So if you get called away or disconnected, you'll still be able to view the full presentation afterwards. And of course, I'd also like to just remind everyone that if you are looking for the closed captioning, that is an option at the bottom of the Zoom control panel as well. So with that, I'd like to welcome our presenters today from Cooperators. So I'm going to turn things over to Joanna now, who's going to kick things off for us. Welcome, Joanna.
Thank you, Marina. My name is Joanna. I'm with Cooperators, and I'm going to be hosting this with you today. And first of all, we're going to do our own Cooperators Land Acknowledgement. There are over 600 First Nations, several Métis settlements, and Inuit communities that, one way or another, Cooperators engages with. It could be providing direct service, by sponsoring local events, having offices on traditional territory, by hiring Indigenous powerhouses, or by Indigenous stakeholders as neighbors. From the Haida on the coast of BC, the Inuit of Nunavut, the Cree of the Plains, the Haudenosaunee of Six Nations, and the Maliseet of the Atlantic, and all of those in between. We thank you for being stewards of this land. And now I'm going to introduce the presenters in today's webinar for you. We have Aaron Calaval, who is a financial advisor owner with Aaron and Associates Insurance Inc. in Saskatchewan. We have Alex Delvand, who is a financial advisor owner at Delvand Insurance Agency Limited in Ontario. We have Lisa Lawson, who is a Level 3 claims representative in the bodily injury area. And we have Nicole Sabo, who is a national specialist with commercial and farm bodily injury. Our agenda today, we are obviously going to talk about directors and officers liability. That's why we're here. What's the purpose of directors and officers liability? We're going to provide you with some real world examples, talk to you about our claims process, and then at the end, we're going to do a Q&A session with you. So now what I want to do is we want to hear from you. So I'm going to pop a poll in the session here that I'd like you all to answer. How many of your organizations already have directors and officers liability coverage? So let's wait a few seconds for those answers to come in. We'll share the results with you, and then we'll move on to our presentation. This is quick. You guys are on the ball today. So right now we've got about 76% of our attendees do have directors and officers liability coverage. We have about 8% that don't, and 15% that are unsure. So we are going to end that poll. I'm going to share that result. Great. And now we're going to pass it over to Erin to do her portion of the presentation. Erin, over to you.
Thank you, Joanna. I'm Erin Calavel. I'm calling in today from Regina, Saskatchewan. Thank you so much for having us today. I'm going to talk a bit about liability insurance before we dive right into directors and officers. I think it's important to understand, what is actual general liability insurance and why do we need to have it, right? So laws in Canada would say that liability insurance, is important for all organizations, profit or nonprofit, to have because they're responsible for the care of the clients who use their services, right? So some of the things that would be covered in a claim for liability insurance are things that you guys already know. So property damage and bodily injury. So we know that if we damage someone else's property or someone is injured or hurt on our property, that we might have a liability issue. Makes sense, right? We're pretty used to that one. Personal or advertising injury, including slander and libel, those do not sound good, right? But personal injury would be maybe not a medical or a physical injury, but slander, of course, is when someone defames you verbally, and libel is when someone defames you in writing. So we would be interested to make sure that we're covered for that in the event that happened in our organization. I think we all know what medical expenses would mean, right? We would want to make sure that if someone was injured in our property, on our property, as a result of our product, that an insurance company would come in, even if no fault was really established, an insurance company would come in and say, hey, we've got to cover some medical expenses and make sure that we respond in that event. So medical expenses would be something covered under liability. And the other thing, just real quick, is tenants' legal liability. So if you're not a real estate baron and you don't own all the buildings that you operate your business out of, you may rent that building, right? I rent the office that my cooperators agency is in. So I have tenants' legal liability to ensure that if I damage the property of the building owner, my liability policy will respond. So those are some of the things we might think of when we think of liability insurance, right? And we have a responsibility to ensure we have that in place. So we're going to talk about what happens with liability insurance. Like, why would I have cause to phone my insurance company and talk about liability? And the reason we would have it is negligence. The sort of triggering event that would happen in a liability claim is failure to provide care, reasonable care, to your clients. And they were injured or damaged because of that negligence, right? So let's talk a bit about negligence. So would we have a duty in our business to provide care for a client? Yes, we do. Did we fail in that duty? Like, did we do something that caused the accident or the damage? Yes, we did. Did our failure to provide that care, did that cause someone to get injured, or did that cause damage to some property? Yes, it did. And lastly, when we failed in our duty, did that contribute to someone's medical expenses, someone's personal injury? If those answers are yes, and we've established some negligence, we've got to talk about a liability claim, right? So one of the things that I think is always the best reminder of this is when you're shopping, let's say you're out and about at Walmart, and you expect the aisles to be clear, you expect to be able to walk around the grocery store free of injury or accident. And then all of a sudden you see the wet floor sign, right? So there's a yellow pyramid on the floor that says this floor is wet. So that company has really said to you, there's maybe some danger here, and we're not negligent because we've warned you of this wet floor. So that's a company who's doing some risk management, right, to minimize the idea that maybe a claim could arise out of our operations, right? So that's just some of the basic principles about how a liability claim might happen. And then we're going to talk a bit about like who would be covered under liability insurance. Who are the people that this policy would sort of help cover? And direct liability in nonprofit or for-profit organizations is like your direct actions in the community, your products, your services, your activities within your communities and doing your business. And also it would cover sort of your indirect activity, and your indirect liability would be your employees, right? Your volunteers, the people that are responsible to represent you in the community. We would have indirect liability, making sure we cover those employees. So that sort of net, that sort of coverage that we provide under liability certainly covers a lot of things. It's a lot of information to cover, but it's really important for every organization to start with that basic liability insurance.
And Alex, I think we're going to pass the ball over to you.
Right. Thank you very much. Good day, everyone. Thanks for having us. Getting to directors and officers insurance. I must say the intent is not here to explain the policy wordings or the technicalities of the policy, because it really varies from policy to policy, from insurer to insurer, or organization to organization. That's why at the cooperators, we developed a specific program for Co-op Guard and nonprofit organizations that the emphasis is on discovering the needs and analyzing the needs, and then providing the right solution for it. So, and there are teams of underwriters, advisors, and claims people that are dedicated into that segment specifically. What I'm going to talk about today is just a general idea of why you need directors and officers insurance, and why, what areas you need to look into it. When it comes to directors and officers liability, unlike CGL that deals with unintended, sudden, and accidental events, with directors and officers, we are dealing with wrongdoing of directors and officers based on what they intend to do. Like, they're expected to make decisions confidently and act upon them with the best intentions and to the benefit of their organization. But sometimes the outcomes of those decisions could result in financial losses for the stakeholders. These stakeholders could be employees, members or shareholders, creditors, vendors, customers, or even general public through the breach of contract, or even sometimes a statement that can make them liable for, or the organization for what's said. The board members or an officers of the cooperative may decide on hiring or firing an employee that can trigger a claim under employment practices, or they might decide on buying an asset or selling an asset or investing the organization's funds or keeping them in cash, like even not investing it could raise questions and raise claims. Or they can just sign a contract or cancel a contract, which again can have some financial consequences. So the more individuals affected by these decisions and the more people that you get involved in making those decisions would have more impact on the needs of the directors and officers. Like you will have more exposure for that. These claims can come against the organization, the entity, or even can follow the board members or the officers personally. So now I'd like to point out a few things that are in the directors and officers insurance that you need to pay a lot more attention to it. One thing is most directors and officers insurance are claims made basis. So unlike the CGL, that the policy that was enforced at the time of an event, when an accident happened, that policy that was enforced at that time would respond. With directors and officers, the policy that is enforced at the time of the first notice of claim, that policy has to respond. So a decision that was made like 3 years ago may come to become a claim now, and the policy that is enforced now has to respond. So it's very important to know whether your policy includes a retroactive date or it's indefinite, and then to understand the insurer that is now insuring your directors and officers, how far back they're going to be there for you. The next thing is defense cost. Most D&O policies exclude defense cost or take it as part of the limit that you're insured for. Some other D&O like ours, we paid the defense cost on top of the limit. So if the entire limit is needed for settlements, we are not reducing your limit for the defense cost. Another thing that I would like to mention is the insolvency coverage. So you need to make sure your policy is good for the time that the organization doesn't exist or it goes bankrupt. For the cost like unpaid salaries or the benefits or the pollution, or there might be exclusions there that you want to just read your policy or know whether or not you need them, or if you need them, the policy is designed to cover them. Coverage for punitive damages, D&O, in most cases, again, excludes the punitive damages. And some of them that cover, they may cover only if it's in a specific territory. Again, just read your policy, be aware of that, and talk to your broker or agent to make sure you understand them properly. The last thing that I would like to mention before we get to examples is coverage territory. Your D&O policy may be limited just for the operation in Canada, or it could be worldwide. Again, if it is worldwide, sometimes it may cover the worldwide operation, but only if the claim is made and handled in Canada. We'll be happy to answer your specific questions during the Q&A, but I'd like to end this part here. Now we're going to cover some examples. If we have the next slide, or I can have, Erin, would you like to take it over and share, explain some of these examples for us?
Yes, Alex, thanks so much. Yeah, so we'll talk a little bit about the rubber hitting the road on these policies, right? Like when would the coverage be required? When would a claim take place that we would have to phone our insurance company? So we have an example here of setting up a booth at an event. I think the summer months are coming and it's pretty common to be involved in trade shows or whatnot throughout your community. So you set up a booth and you don't secure the premises. Maybe there's some cords exposed or there's some debris around your booth and a person trips over a wire that's lying around, hits your presentation table on the way down and gets a concussion. Yikes, this is a tough day. This would 100% be a phone call that you would make to your insurance provider under the general commercial liability, the CGL that Alex was mentioning before, right? There's not a D&O issue. This is a liability issue, a trip and fall. Someone's injured. Maybe there's some medical expenses that need to get paid. And we've done something here that we used in the example earlier, right? We didn't warn people of the danger and we're negligent. So we've done something in this booth to cause an injury to someone else. So, you know, we may not think that will happen to us, or we may not consider Canada a incredibly litigious country and people don't want to go around suing co-ops and nonprofits. But the fact of the matter is, when you operate in the community, you don't secure your premises and someone is injured, this is a liability claim. This is a liability issue that's just occurred. We have another quick example here. So this isn't a test. You won't be required to answer questions about this later, but if you're the tenant in a space on the 5th floor, this is the example, and you have a drinking fountain that leaks during the night, so a water fountain or whatnot for your clients or your staff. It leaks through the night, no fault of your own, but these things happen. The leak causes water damage to not only your floor, but all 5 floors below you, where other businesses are also renting in that building. So we've got a couple things happening here, right? If you remember back to CGL, again, this is a property damage situation, not a D&O event. This is a commercial general liability event. And we're going to have sort of 2 areas of coverage on the policy. One would be the damage done to my landlord's flooring, my landlord's property where I rent. We're going to access our tenant's legal liability to see what coverage we have there to make our landlord whole again. And the other thing is that our commercial general liability will have to respond to the damage that we caused to all the floors below us. Now, this could be a scenario where, you know, the building owner might get involved and whatnot, but essentially our commercial general liability, our tenant's legal liability will cover or will be needed to cover a situation that arises like this one. I think there's more examples for D&O. Alex, do you want to chat about these?
Sure, thank you. Yes, this example is about an employee dismissal, could be claim of wrongful dismissal. Because there's a financial loss, there's no bodily injury or property damage. On an easy analysis, we can say that it's a D&O claim under the employment practices. Whether or not this claim ends up to be a settlement and who's really at fault or not, or what the damages are, there will be some legal expenses and defense costs there that your D&O policy will pick up. As I mentioned in my actual presentation. The next, on this example, the organization fails to send the information to the vendor or to another stakeholder that was expecting benefits or financial gain, but because again, our negligence caused that damage, or our client's negligence, the financial loss is not going to be covered under the CGL. So directors and officers insurance can pay here. If it was a professional service, then might have been an E&O because of the error, but If it's just a general contract and general agreement, usually it's DNO. I think it's time for claims people to take over and share some of that.
Yeah, so I'm going to pass it over to Nicole.
That sounds good. So Lisa and I will be talking on the next few slides about the claims process. So reporting to the insurer, Alex already just defined earlier what a claims made policy is. So a claims made policy is triggered by the notice of a claim. A report should always be made to the insurer when there's any circumstance that could be reasonably expected to give rise to a future claim, or when the notice of claim is received. It's the right time to provide the insurer with a basic description of what the claim is about. For example, if it's a discrimination claim or a wrongful dismissal. This can speed up the process for the insurer to assign to specific adjusters within the claims department to the specific type of claim that is being reported. It would also be helpful at this time for the insured to advise who is best to contact and the contact information for that claim, and to also provide a copy of the notice of claim so that we can set up a claim with the proper date of loss. Any expenses incurred prior to reporting the claim to the insurer do not have to be reimbursed to the client. And this is one of the reasons why it's super important for the client to report any possibility of a claim as soon as possible, to probably keep their out-of-pocket expenses lower if there is coverage determined. And then the next slide is what the claims process looks like. So the client can expect to be contacted by the insurer within 48 hours from when the claim makes it to our team, and the claims adjuster assigned to the claim will explain the claims process and what is required of the client for the handling of the claim. I'll pass the next slide over to Lisa.
Hi, everyone. I'm Lisa Lawson, and I work in the bodily injury claims department. So typically when we get a claim of, they can come from various areas. It can be wrongful dismissal, it can be harassment, it can be a number of issues. And so often not having all the information at the onset, we process through what's called a reservation of rights letter. And what that does is it allows us as adjusters to investigate the claim without any form of commitment of coverage. And this is really important because quite often what happens is we don't always have all the information. So, you know, you don't want to put the cart before the horse and say, oh, sure, there's coverage in force, when in fact, you don't know if there is or isn't. Often what we require is we need all relevant information, record of employment. We need to know if there's minutes meetings, any type of relevant rules, regulations, bylaws. And we always try to get a recorded statement from the insured. And we try to do that, if at all possible, simply because years can pass before such time we get to litigation. Often these files do go to litigation. And so to have your client insured or volunteer or employee, whomever it is that needs to be the representative and give evidence under examinations of discovery, it's really hard for them sometimes to go back years. I've got files that are 10 years old on my desk. It may not even be the same executive director. So we always try to do that for accuracy and part of our claims processes to ensure that everything is clearly followed. So once we get all the details together, the next step is always to review the coverage. We compare it with regards to the endorsements that the insured may have purchased on top of the policy itself. We also look at if there's any applicable exclusions. And once we have all the information in front of us, we can make a decisive decision. And then from there, once we've determined if there is coverage, and sometimes there can be partial coverage and sometimes not. So a prime example is the financial component. So if an insured has released an individual from their employment, for example, and perhaps the key area of the allegation is that it was a wrongful dismissal, whether it was with or without cause, essentially what happens is the financial component, if anything is owing, is not covered under the policy. That being said, there may be other areas that are triggered, such as negligence, that puts the duty to defend into play. So quite often we will review all of that first. If in fact we determine that there is a duty to defend, then we follow up with the insured, we advise them, and in some cases we provide a revised reservation of rights letter, which may then, from the initial one, because we have more information, allow us to actually detail. And we will capture that. So while we still may not know down the road if there's actually indemnification for, say, a pain and suffering situation, which will trigger indemnification, say a psychological component, we can then at least tell the insureds right from the get-go, we are going to provide the defense, but you have to realize that any financial component that is assigned to you for compensation is not triggered for coverage. And again, quite often we end up in defense because many of these claims are very emotionally driven and people are invested. It's a financial impact both for the nonprofit organization. It's also quite often there are underlying issues emotionally with the individual who's no longer an employee or volunteering. And we apply the deductible when it's warranted. So if we're only paying defense costs, we don't apply a deductible. If we end up having to pay some type of indemnification, then that's when the deductible is applicable. And that's up to us to continually communicate that with the insureds as the claim proceeds. Next. Any questions? We have lots of examples of claims. If anyone has any questions, I've got about 4 or 5 examples that I can certainly outline. They're very quick. So let me know if anyone's interested in that.
All right, thanks, Lisa. Thanks, Nicole, Alex, and Aaron. We do have some questions in the chat here. So some of them are coverage questions, some of them are claims questions. Absolutely, some of the answers might require a little bit more research, especially anything that's global or US, and we can definitely send a better breakdown of the answers to the Charity Village people after everything is all done. So I'm going to start with the first question here from Tanya. We've got, can a non-incorporated national not-for-profit organization, no legal entity, access D&O insurance for their board members? My assumption is no, but looking for confirmation. Aaron or Alex on that one?
I can answer this. The cooperator sometimes considers a group of individual organization, like they allow them to have D&O policy and CGL policy as an organization under these special programs. However, our specific D26, which is our directors and officers entity form with a little more generous coverages, they're not available to them. So it depends to the insurer.
Okay, thank you, Alex. From Lisa, hello, we do have D&O insurance. We have 4 signatories for bank and financial matters. One of them is not a board or an officer. Is that a risk? Again, this is a question for Alex or Aaron.
Would you read the question again? Sorry.
It says we do have D&O insurance. We have 4 signatories for bank and financial matters. One of them is not in the board or an officer. Is this a risk?
It is a risk, but the solution could be in partially on the crime coverage under the CGL. If there is an employee dishonesty, it's part of the crime coverage. It really depends. We need a little more information to know really what their concern is and how it could be addressed.
Great.
Joanna, I wanted to jump in for just a second because I think we might have a typo in the email address that's on the slide. I'm guessing it should read strategic. Is that correct?
Absolutely, it is.
Amazing. It happens to us all. We just had someone mention that, so I just wanted to jump in, make sure that folks, can contact you at the right place. I'm just going to pop that email address into the chat, everyone. Okay, so you can access it there.
Okay. All right, we're moving on to Jim. Not sure if this was answered during the presentation, but how does D&O and workers' compensation work together, particularly for volunteers, and in what capacity? Alex or Aaron?
Sorry, this is Erin. I was definitely like trying to unmute and I wasn't earlier. So sorry, Alex. I would be really honest with you, Jim. This would be something that you and your insurer, your financial advisor would work on together in terms of D&O and WCB. Alex, I don't know if you have any experience with this, but I would suggest we take this one off and provide an answer for Jim from a coverage perspective and how WCB works together with volunteers. Excellent question. But I think we might need to come back to that one.
Okay, thank you.
I have to add again, there is a blanket accident coverage that covers the volunteers and directors and officers if they get injured during the course of doing their duties for the organization. It's a separate coverage that your broker or advisor can add to your policy. WSIB pays only if the injury happens during the course of employment, and they must be on the payroll, and the WSIB premiums must have been paid through the payroll. That again is not a complete answer, it's a general answer, but as Aaron said, like we need more information to determine that.
Thanks, Alex. Next question from Roland. We are a nonprofit organization and planning an information session on rented facilities and sometimes in a place of residence of our clients. Do you offer liability coverage for these events?
Yes, Roland, it's Erin here. We would extend coverage to these rental facilities as long as your provider is aware of that exposure and that location is perhaps listed as a premises on your CGL policy. We often have clients, like in our example before, that would rent a facility for to set up a booth or to set up an information session like you mentioned here. Let your provider know, ensure that it's a location that your provider is aware of. And I think you would be able to provide liability coverage as an extension to that location. Alex, do you have anything maybe to add to that as well?
No, your answer was complete.
Okay, Roland actually has another question, Aaron and Alex. He's involved in another nonprofit organization. He's a busy guy and planning for cultural events in a rented facility again. The event is 2 hours. It's a cultural show with acting, singing, dancing, arts display, and other activity. What kind of coverage can we provide?
Aaron,
yeah, Roland, he is a busy guy. I love this, all these activities. And I think very similar response, discuss the event with your provider and an extension of coverage for these temporary locations where you might be doing an event, like you're saying. There are insurers in the market that just do one-off event liability. So there, you know, if you aren't someone who has a really fulsome liability policy with your nonprofit, there are still providers for event coverage. So again, maybe a question for your broker, but if it's something that that can't be added based on the nature of that event, maybe the dancing or some of these other activities, you would certainly be able to find a market for that kind of one-off event coverage. So a couple different avenues you can explore, Roland.
Okay.
If
Thanks,
I
Erin.
could add something to that, would be there would be a couple odd exposures there. One is if the participants are children, you may want to consider the sexual abuse and misconduct coverage with your current CGL or on that event policy that you're considering. And also if, as I said, like they're not generally, I don't think your question is going that far in details, but if it is, if the event also includes teaching, then depending on what it is, let's say if it is a professional service or professional that is teaching, then E&O may be required. So you don't have to have E&O for setting it up, but you may want to ask that person that's providing the lessons to make sure they are insured and they have E&O and CGL as well.
Thanks, Alex. We've got a question here from Gary. For D&O, is there a generally accepted definition for officers? For instance, is a senior level employee reporting to the CEO covered, even though they aren't a director or officer of the organization?
During the application, we asked for a list of directors and officers and their roles and responsibilities, and we considered that during the underwriting. So you would know exactly who is covered and what for. You have to just share those details with your advisor or the underwriting team to make sure you have the right coverage for everyone.
Okay. Thank you. We're going down to Anonymous. When is it reasonable for a vendor to request to be added to a company's policy that is purchasing the services as an additional insured? Not sure that's D&O, but.
Sorry, Joanna, when is it reasonable for a vendor to ask to be added as an additional insured?
Yes.
Well, my answer would be anytime there's some shared risk there. And to be honest, I believe that it's important that if there is risk from a vendor on the actions of your organization, I think it's reasonable for them to be named on the policy as soon as you're undergoing a contract together, or there's some shared risk within operating tangentially with that corporation. So I don't know if it's reasonable. We get asked constantly to add vendors to CGL policies. We always question, what is the business? Why, like, is there a contract? Why are you involved with that organization? What's the nature of this relationship? And like Alex said, we present those scenarios to underwriters. And if the cooperators or your insurance company or underwriting team don't believe that there is a risk or don't believe that that is a reasonable request, often they'll not agree to add them as an additional insured, or that there'll be more information that would need to be back and forth in order to complete that.
Okay. Just looking for some claims questions here. Here's one. When is it too late to submit a claim? In the case of a claim of wrongful dismissal, at what point would you not be able to address this with your insurance provider? Nicole or Lisa?
I can jump in on that. That's a bit of a difficult one because the D&O is a claims made, not an occurrence. So that's the first thing to remember. And the other issue is that in the policy wordings, it specifically says that within a reasonable time frame, when you ought to have known that a claim was forthcoming, you should always report it. Because what happens is you could prejudice our position in order to defend you and protect you financially. So I had one years ago where the client, and I totally appreciated it, the client had no idea that they even had the coverage. They didn't report it to us for, I think they were well into it for a couple of years. And then they were speaking to their agent, they reported it because the agent said, well, you should pass it along to claims. So in that case, it turned out that it wasn't great for us, but it clearly, by not reporting it, did not prejudice us, but it's something that we would look at, and it's case by case situation. And it's really important that as soon as you think, even if nothing comes of it, as soon as you think you have a claim, you should report it immediately, because these things morph into other problems, particularly these claims. And it prevents us, with the passage of time, of investigating, gathering materials and critical evidence. It also prevents us from letting these claims explode into something else, which I've also seen. So they sue just a couple of people and then they're not getting what they want. So then they name everybody on the board. So it's just always preventative. Report it as soon as you think that something may surface. Even if you don't think you've done anything wrong, we're not here to judge. We are here to protect you and to represent you and to navigate and guide you through the entire claims process. That's our job, and we're passionate about it. And that's so important to us to build that relationship with our clients.
I would say too, Lisa, generally for wrongful dismissal claims, they don't get late reported to us. People present their claims pretty quickly on those ones. Generally, they're not the late reports that we get. We get more late reports on the CGL claims, not necessarily the DNOs.
And the defamation is something else that often gets reported late. But yeah, that's bang on for sure, Nicole.
Lots of requests for examples. And this one here says, what are the most common claims you see and advice for prevention of these claims? And then we have never had a claim. So very broad.
Well, CGL, Lisa and I will both agree that it's slip and falls. Slip and fall and trip and falls would probably be the vast majority of the claims that we see under the CGL. Those are definitely. Under the DNO, we have a lot of human rights claims, a lot of wrongful dismissal claims.
I have some examples that I can do in about 2 minutes in preparation for this, just to give a sense. So example one, and these files are open on my desk, by the way. So I have a date of loss of July 2015. Okay. So, and to date, we have paid legal expenses of $12,626. And it was a situation where Ontario matter involved a sexual assault to a minor. A tenant at the complex was assaulted by another tenant. The plaintiff was a resident of the housing complex, and that individual was assaulted by another tenant. The perpetrator has disabilities, and so it has turned into quite a problem. There is a DNO and an EPL policy endorsement added to it. So the big issue on this one is there's coverage issues, both for the perpetrator and for the parents of the perpetrator. And so, and these cases take a really long time, because in this one, we're dealing also with the public guardian trustee, and you usually have child and social services involved in these situations. And then my other example is date of loss, March 2015. We've paid $26,700 so far, and it's a defamation claim. One co-op member is alleged to have defamed another one and ruined their reputation. Sadly, we see more of these than we should. You get bickering and in-house fighting on various boards, and individuals get very emotionally invested, and those often morph into a lot of other problems. Policies triggered for a duty to defend, but not to indemnify. And again, you can appreciate a lot of these people are still living in the housing complex. So they're surrounded by it day in, day out. So they take years, and we're defending it, but we can't indemnify because there's no coverage. So we sort of hurry up and wait. It moves at a glacial pace, shall we say. My other example is July of 2018. We've paid $30,584 already on a human rights wrongful dismissal, and we have no indemnity. It's strictly a defense, and it is alleged that the individual that was let go improperly, and they are fighting in litigation. Another example, November 2017, we paid over $8,000 in legal, discrimination and harassment at a co-op housing. One individual feels that because she is married to somebody of another ethnicity and has children that has different colored skin, that other neighbors have been picking on her. And those are my examples.
Great. Lisa.
I answered one in the question Q&A, and somebody had asked what the EPL stands for, and it's Employment Practices Liability.
Thanks, Nicole. Sorry.
Yeah.
I talk claims lingo.
We use a lot of short terms.
I apologize. That's how my brain is wired. Sorry about that.
One more claims question here before we pop back to Aaron and Alex. We coordinate many workshops throughout the year. If during a workshop a participant trips and falls or an accident occurs, who covers such injuries, and is a waiver sufficient?
So waivers are always a topic of discussion in our claims department. So waivers are sometimes relied upon. We will use the wordings, we'll review them, but waivers don't always stand. And we've been told that over and over by judges that waivers are not the be all and end all to try to limit your liability in any situation. I think there's some ski hill examples. We've had quite a few like trampoline parks. Those types of waivers, just people don't really review them. And judges are saying that because people aren't expected to review the entire waiver, that they don't hold up very well. And I think as to the question, it would depend on where it was happening, what location it was. Like if somebody tripped and fell and it was an external building that you had rented for the afternoon, there would potentially be other defendants. If it was like some impurity in the floor or a step that wasn't up to code, we would be bringing in multiple other parties, anybody who had to do with the ownership or the maintenance of the building. If it was within your own office or your own property that you owned and were expected to maintain, then you could be held negligent.
Yeah, and on the waiver, it's not applicable to children. So any minor, anyone under the legal age, you cannot apply a waiver to them.
Yeah, because they
so
can't
even
read
if
it.
a parent, so I have one right now where a little girl was in our after school program. She was ice skating and she tripped and fell and slit her lip wide open and had broken teeth and so on. Her parents signed a waiver. Regrettably, the waiver doesn't mean anything for us. We can't rely on it as a defense.
Good information, Lisa. Thank you.
I think generally waivers just don't hold up. They're just really not something that we can rely on very heavily at all.
No, because most of the time too, and Nicole jump in, of course, but because she's my boss. But one of the things, so she sees all of these, but one of the things that you have to remember too is that unless the insured, I have one right now with 2 adults and it's a potential brain injury, but the individual that signed the waiver, nobody confirmed that they actually read through it and went over it with her and signed and initialed it before. So it's really difficult on those ones. And she mentioned the ski hill. Yeah, very, very difficult.
Okay. Back to Erin and Alex here. How does it impact an organization's premiums if we receive a lot of frivolous and vexatious claims? For context, we regulate a health profession in British Columbia.
Well, that's a great question for us. And Alex, I'm interested to hear your take on this as well. And I love that someone used the term vexatious. Like that is just, that's a game changer. Great job. Yeah, claims definitely impact premium. And premium increases happen when the cost to administer that policy, whether those claims are successful, whether those claims pay. When we handle claims activity, that is costly for the organization and the client. There's lots of things that help in those situations. You know, there's lots of mitigating factors with premium, and it may sound very oversimplified, but deductibles help with premium dislocation when claims are accessed. And like Lisa and Nicole have mentioned, like we need those claims reported. We always want to be aware of potential claims. But I think when an underwriter reviews premium and overlooks the premium of a policy and the risk that the insurance company has, frivolous claims or claims that didn't cost the organization, the insurance organization, would certainly attempt to be tempered in a premium situation. But you're right, having those claims constantly does affect premium. There's no soft way to answer that, but there's other mitigating factors for premium that a good broker or advisor would help the organization out with.
Thanks, Erin. So this next one here, it's a Canadian professional association with board members and staff in Canada only, but who oversee a global program, and in brackets, sending technical experts overseas. Should they have worldwide D&O, or is Canada coverage sufficient since board members and decision-making is in Canada only? Alex or Erin on that?
Again, that's something that we consider during the underwriting process to see what the exposure of their activities are. Sometimes their operation is worldwide, but they're really doing everything from here, and their liability is very limited. But sometimes it involves travels or sharing material overseas, and that's all the underwriters' consideration to see if they want to take that risk, or where to limit it, where to exclude it, or where to include it.
That's absolutely true, Alex. I actually insure a client with a global, like a nonprofit with a global sort of reach. And based on a review of their operations, the budget, the exposure overseas, and some few other factors within that organization, we were comfortable with Canadian D&O. But that's an excellent question and a lot more common, I think, than you know, maybe a lot of people would think. But this particular risk was satisfied with, and we were satisfied with Canadian D&O coverage, but an excellent underwriting question and something to, you know, something that would need to be reviewed in detail individually.
Thank you. We are coming up to the hour. Marina, I'm not sure if we want to answer a few more questions or if we want to wrap up.
Sure, Joanna, if your team is game to stick around and wants to address more questions, we can absolutely do that. I'll just remind everyone who might need to jump at the hour that we are going to record the full Q&A along with the presentation. So you'll get that email tomorrow with the full video recording and the PDF of the slide deck. So If you need to head off to other things today, thank you for attending, and we hope you have a great rest of the day. For those who want to stick around for just a little bit longer for a bit more questions, I'll turn it back over to Joanna.
Thank you. Maybe we'll take 2 more questions and then wrap it up. I know Alex, Aaron, Lisa, and Nicole are very busy individuals. Further to the question about defining officer and who's covered, what's the best practice for updating your policy? Example, when your staff structure changes, new employees are added, directors, officers leave, etc. Alex or Aaron?
Well, just communicate with your broker or agent any changes that happen, even changes in roles and responsibilities, because the insurer is insuring your risk based on the facts that they're aware of. If something is not really brought to their attention, and especially for D&O and E&O that are very specific, the best practice is just to share any changes with your broker or advisor.
I have a pretty tried and tested rule with lots of my nonprofits is when they have their AGM, I want to diarize and know when the AGM is, because that's a great time to do a review of that insurance policy and make sure the players at the table and the people involved in that AGM for that nonprofit, when they have their review, I want to have a review with that D&O policy. So even if there's not a lot of turnover or you're a pretty stable organization, I would say an annual review, just like your AGM, is recommended for sure.
Okay, and I'll finish up with a claims question here. It was mentioned earlier, if I'm not mistaken, that coverage for the claim happened a couple of years would need coverage on the time that the claim is filed. Is that right?
Can you repeat that? I'm not sure that I understood what the question was.
So it says, it was mentioned earlier, if I'm not mistaken, that coverage for the claim happened a couple of years ago would need a coverage on the time the claim is filed. Is this right?
So the example that I gave, if that's what the question refers to, in the late reporting, is we reviewed it because the client, it was genuine. They had no idea that they could actually report it to us. So it was a few years post-incident, but because it was a claims-made policy and not an occurrence-based, the timelines in which it was reported to us, that part of it is fine because it's claims-made and we had the policy for a long period of time. The issue in reviewing the coverage was whether or not the insured had prejudiced our position by not reporting it to us. So was there any triggers that now put us in a negative position? And we have to look at it case by case. And in my example, we did cover it because there was no prejudice to us. And then we had to discuss with the insured the legal expenses that they had incurred, because that did prejudice us because we use vendors. So the insured's lawyer was charging $500 an hour, and we negotiate by way of corporate and a number of other entities to negotiate with vendors. So instead of paying a lawyer maybe $500, sometimes we negotiate, and maybe I'll see a lawyer that I would have assigned it to that it would have only charged $320 an hour. So that puts us in a bit of a precarious situation. And so we negotiated with the insured on that basis that this is what really should have happened. But it was appreciated, and you have to be respectful. It's up to us to provide procedural fairness to insureds and look at each case and why it wasn't reported to us. There are times, though, where you see the repeat issues. Unfortunately, some clients just seem to have some unfortunate luck. And we look at it and we say, well, you kind of knew because you're still dealing with me. How come we didn't know about it? So, but in fairness, again, sometimes there's changes of executive directors, or there's an interim director, or they've had a huge influx of staff changes. And that also has occurred. So I may be talking to the 8th person in the last 2 years. So again, very much case by case.
And that's the perfect, it went back to my example earlier about that we're not obligated to repay back incurred expenses, especially on late reports. And that would be a situation where we would take it into consideration and we would see if the late report was reasonable and if it was not prejudicing us, if it was intentionally withheld from us. And we found out maybe through a third party or through a lawyer, then it could be a different story and we could refuse to reimburse. And that client may have had full coverage with us paying all the legals from day one, had they reported it to us. So that's a great example of the importance of early reporting.
Great, thank you both. I think we are going to wrap up. There's so many questions, more questions than we could get to. I think that the best way to get those questions answered would be to reach out to the strategic client management at cooperators.ca, and then we can connect you with an advisor that is local to you to answer your questions. So thank you very much to Nicole, Lisa, Alex, and Aaron. This was absolutely great. Marina, I'm going to pass it over to you.
Wonderful. Well, thank you, Joanna, the entire Cooperators team. We want to thank you for presenting such an informative webinar today. I know we did have a lot of questions that unfortunately we just didn't have time to get to, so please do reach out directly to that email address. It's there in the chat comments as well if you want to do a copy and paste. Just wanted to remind everyone before we sign off that you'll get that follow-up email tomorrow with the link to the webinar recording, the PDF of the slide deck, and some of the resources that we shared today. Please feel free to share this link with your colleagues, your board. It's all publicly available for anyone to access. The email will also include a survey link that you can fill out with your feedback on today's webinar, but you should also see a survey link pop up right here in Zoom following the session as well. And we always appreciate if you can fill that out, and we will pass your feedback along to the Cooperators team as well. On behalf of Charity Village, thank you again for joining us today. I hope that you will join us for our next free webinar, which is coming up soon. It's on expense management during difficult times. So please do join us for that. You can find that and all of our upcoming webinars at charityvillage.com/webinars. Yeah, take a look there and see, we've got some good stuff coming up over the summer. So thanks again. I wish you all a wonderful rest of your day, and we hope to see you again soon. Bye-bye for now.